Yes, sir.
If I can address the court briefly. I filed a supplement to the Mr. Kendrick's motion for a mistrial this morning. I just want to make sure the court's aware of it.
I am aware of it. I have not yet had a chance to look at it, but that's got it.
Thank you, Your Honor. Mostly I want to make sure I bring it to the court's attention because, again, and I've followed the request of the court to not argue what's already in the papers, but I just want to make sure that the court understands that based on this additional information that we learned about the July 7th meeting, that my client has been consistently denied his right to a fair tribunal. It's been a due process violation. I, like Mr. Shart, am extremely upset having read that transcript. Myself and my fellow outside agitators over here, I assume that they are upset as well. And
I don't think, honestly, I don't think that that reference was to anybody who is a member of the bar. I think that there have been times in this case where members of the public are in the courtroom, which they are, of course, entitled to be, but communicating in ways that are not appropriate.
well, you know, the problem, Your Honor, is that since this was an ex parte meeting that should probably have never taken place, you were not there, I was not there, my fellow outside agitators weren't there, we don't have a video of it, so I have no idea specifically if that was not referred to us. We don't know, do we? We don't know. And what I do know is that I have been arguing with people for 18 months that Chief Judge Glanville was doing his best, that he was trying to rule to the best of his ability based on the evidence and the law before him. And now I have been made to look like an idiot. So I do not believe that this trial should continue, Your Honor.
I understand. Thank you. I'll take your supplement under consideration. Like I say, I haven't, obviously you just filed it and I haven't had a chance to look at it yet, but I will consider that in the overall context of the motion I was already considering. And, you know, I don't know that everybody's not going to want to come up here and do their 5 minutes of how outraged they are. If y'all feel like you need to get it off your chest, come on. Now's the time.
Okay, I got one more thing to say there. And then I'll sit down.
Okay.
And I don't believe that this is performative outrage, Your Honor.
I mean, I don't either.
Okay.
I don't either. I already said I understand.
In July of 2023, after months of me complaining about late discovery from the state, which should have been produced in December of 2022, when another terabyte or so tranche of discovery was produced to us, I begged Chief Judge Glanville to put a hard deadline on the discovery being produced from the state. He refused to do so. And you know what Judge Glanville's response to me was when I will tell you. I will tell you what his response was. If this was a civil trial, I would keep this out. But since this is a criminal trial, it's coming in. If this was a civil trial, if it was about money, I would keep it out. But since it's only about Mr. Kendrick's life, that last part obviously wasn't in there. But if this is a civil trial, I would keep it out. I've been a civil litigator for 25 years. I agree that if it was a civil trial, it would be kept out. What I'm shocked by, and I'm new to criminal, what I'm shocked by is that the standard would not be higher in a criminal trial. But what did I say to people? Chief Judge Glanville is doing his best. He is doing his best. And now, again, I don't even know what to say to my client, Your Honor.
All right. Well, you know.
What do I say?
I don't know. Obviously, I don't know what to say right now either. But I think that, while again, I understand frustration, you know, let's be careful about disparaging a respected judge. I do think that he has, and I haven't looked at every transcript yet because they haven't all been produced yet, but I don't think you're wrong that he has been trying his best and doing his best. And, you know, we all as lawyers know that everybody talks about lawyers trying to herd cats, and that's not inaccurate. This is a big case. There are a lot of good litigators on this case, but with a lot of good litigators probably comes a lot of egos as well. And I think sometimes it is possible to sort of get so enamored of your position and of winning a point that you are focused more on that than on backing down and taking a breath and being amenable to hear what the other side is saying. And hell, that's true in our whole society right now. Should have said hell, but y'all, I mean,
You're
all right.
Those were not my words. Those were Chief Judge Glanville's words. If this was a civil trial. Well,
I don't know why it was. I don't know what evidence you were talking about. I'm sure there have been evidentiary rulings that have been frustrating to both sides. I will look at the two transcripts and I will make a ruling. And again, I don't think that the characterizations are exactly accurate, but I'll consider it all in context and I'll make a ruling.
Thank you.
All right. Anybody else, or can we move on to evidence? Mr. Steele.
So there are 16, and good morning again.
Good morning.
Good morning, Madam Court Reporter. Ms. Winfrey, there are 16 hours approximately of the video audio you're talking about.
Okay.
And yes, we were going through to dissect objections, but I, and among others, really had an overall objection because the witness testimony, which is before the afternoon of June 12th of 2024, he agreed that he said these prior statements. So over objection, and the way I understand the law, the state shouldn't have been able to put it in at all. So I understand what you're doing. You know, okay. We're going with you, but I just want you to know that we're not conceding that the way it came out, and obviously it's going to be redone after, I believe. I heard what you said. Yes, I agree, but that's the law. I don't believe that it should come in at all. So before you tell us later, hey, why'd you make me do that?
No, I understand. And I think that Mr. Shard had actually put that particular objection in writing in one of your filings anyway, essentially that to the extent that Mr. Copeland said, yes, I said every one of those things to police officers, but every one of them was a lie. That is an admission that he made the statements. And the defense position, as I understand it, is as long as he acknowledges the statement, then nothing else is a prior inconsistent statement. And I'll hear from the state with regard to that, but...
I had one thing. Just another layer of that. Oh, I'm sorry.
Go ahead.
Just another layer of that is that the issue, the subject matter of these statements is largely the alleged co-conspirator statements, that our stance is that those were not in furtherance of conspiracy either. So there's like two layers of analysis.
Okay, thank you.
I'm sorry for interrupting.
You asked, I let you. But anyway, with regard to, does that make something said that is inconsistent in a prior inconsistent statement? And the state can provide me the law on that. But I think there are times when either an I don't remember or an I don't know or a, well, that was a lie, can still form the basis of making something a prior inconsistent statement. So, but
And Your Honor, I'm going to let Ms. Hilton speak specifically as to the law on factually what Mr. Copeland did say. What he said was, I don't remember anything that I told the police. I keep telling you, I don't remember anything. But if they say I said it, then I said it.
Yeah, I think what they're talking about is he also at certain points said, yeah, I absolutely said that, and it was a flat out lie, and I'm paraphrasing, but
Okay.
that is what they're talking about, correct?
If that's what they're talking about.
Is that what y'all are talking about, Mr. Sharp, Mr. Steele? Yeah, so that's what I would like for y'all to address.
Your Honor, we believe based on two positions, OCGA 24-6-621, which be impeachment by contradiction, as well as a prior inconsistent statement, in both that statement, I said all that I said, but it was a lie, or I was trying to finesse my way out of being locked up, would lay the grounds of still allowing the prior inconsistent statement in to come in.
Okay, and 24, the 24-6-621 is the
Impeachment
by contradiction, and 24-6-613 is essentially prior statements, right?
Yes, Your Honor.
So what I'd like is some case law that represents the proposition that you are asserting, okay?
Yes, Your Honor.
All right. And I don't want it just simply quoted out of a horn book. I would like the actual case law.
Your Honor, if you can give us a moment, just because
Okay.
we need to.
I mean, y'all, when I told you a week and a half ago that I wanted to be going through Mr. Copeland's evidence, y'all had 10 days or more to get ready for this. So I don't know what y'all thought we were going to be doing, but yes, I'd like to hear it. So if you need a minute to get me the law, go ahead. Is there, we can also do this portion after lunch and do something else right now, because I don't know that we all need to sit in court and do our research.